Jack Smith going after Donald Trump using his cell phone now. In addition to raiding his residence and Melania's sock drawer, we've now got access to the president's cell phone, and they want to use it to pinpoint where he was geolocated in the White House on January 6th. And they also want to look at the web pages that he may or may not have visited and the things he may or may not have sent to other people. We know that Jack Smith got the Twitter warrant access, so we already got anybody who liked Donald Trump's posts. All of his DMs were all captured in that, and now they got the cell phone too. So we're going to go through two filings. One is Jack Smith's cell phone expert witness disclosure. He's saying, Your Honor, Judge Chutkan, when we get to trial, here's what we intend to do. We've got these three people. We're going to share who they are. We've also got an objection from Jack Smith against Donald Trump saying, you're not entitled to discovery. Why do you need evidence? You should just plead guilty and take the sentence. And then we're going to go through some reaction to what SCOTUS has done, because they did accept Jack Smith's panicky request to really expedite this entire proceeding so they can get this done before the election starts in March, when the primary Super Tuesday date is. We also got reaction from Marc Elias, the Democrat super lawyer, and others, but let's just dive right into it. So Jack Smith wants Trump's cell phone, may already have it, and may have some good stuff in there to use. We don't know. Or maybe there's nothing in there at all. But this is what he is filing for us. It's a 3-pager, not long. It tells us that this is the government's summary of anticipated expert testimony, and the trial is on hiatus right now. The January 6th trial is not scheduled for March. I mean, it is technically scheduled for March, but the likelihood that it goes on March, I would say, is very slim, because they know it's currently on pause. So unless the Supreme Court really gets moving on this thing and we have oral arguments, or maybe they issue something that they do without the oral argument, who knows what they do. But it's likely that that date is going to be movable now because a bunch of stuff has happened, and Jack Smith expedited this, right? He is the person who leapfrogged the Court of Appeals and took this right up to the Supreme Court. So it's on hiatus, but we know that they're asking Judge Chutkan to keep the train on the tracks in case the courts come back quickly. They're ready to go. Boom. Because that could happen too, right? And they're planning for all contingencies. So they say, here's the deal, Judge Chutkan. January 6th case out of the District of Columbia. The court now submits the court's brief description of each expert witness's area of expertise and expected testimony. Why? Because the judge ordered them to do it. Saying, Your Honor, as explained below, the government may call up to 3 expert witnesses to testify in this case. And it's just a may. They're not required to do it, but they're just noticing them. They say the first expert, pretty skilled guy or gal, says that this person has knowledge, skill, experience, training, and education beyond the ordinary layperson regarding the interpretation and visual representation of geographic location data. So they scrape all the details off the phone and they can do something with it, make it look pretty. The government expects that expert 1 will testify about his or her use of ArcGIS, Geographic Information Systems, software that's going to create a map of the Google location history data produced in response to a search warrant. So you know how in Google you can go your history, it says you were here for 10 minutes, you were here 2 weeks ago, you were here 3 months ago, whatever. They can reassemble that. Now specifically, expert 1, who's already done this, plotted the location history data for Google accounts and devices associated with individuals who moved on January 6th from an area at or near the ellipse to an area encompassing the United States Capitol building. So from the ellipse to the Capitol. Now, who were these people? Who were the individuals? They're not referencing the defendant, so we'll see. Now, his or her testimony, meaning the expert witness, will describe and explain the resulting geographical representations of that data. And when they put all this on the charts, it's going to aid the jury in understanding the movement of the individuals towards the Capitol area during and after Trump's speech at the ellipse. So it may not even be for Trump, right? Just individuals in general. So it's like they're going to say Trump said a thing and Trump's statements caused all of these things to move, right? What I'm imagining is this fancy geographic rendering, right? I can just envision it now. They have Trump's speech on this frame of the video, and Trump is speaking right here. He looks great, right? This is him, fantastic hair blowing in the wind, and he's doing a great job saving America, speaking about rigged elections. And then simultaneously, they have this geographic recreation. And you see a big group of people kind of all scattered around here, right, at the outset, and they have the time clock at the bottom, and they played the time clock, and they just like Liz Cheney had for us. And it almost looks like a Chick-fil-A commercial or something right now, but this is what you have here. And then this is the time clock. The time clock's running, and Trump says the thing, the bad phrase, right? Fight, right? And then what happens is these people start to move, right? Like a football game, right? They all move this direction. And he says, okay, so what that's going to do is show that Trump said the thing and all the people move simultaneously, something like that. And he's going to come in and it's going to show Trump's words did it. They weren't moving until he said the thing. And then people started texting each other, and the texts corroborate this. And there's, attack the Capitol, blah, blah, blah. So that's going going to be expert number one. Now, expert number two, he's going to have knowledge and skills and training, and he's also going to have expert education beyond the ordinary layperson, which is the standard. You can't just bring in some bro to come testify. He's going to talk to the ordinary layperson about the analysis of the location data and location history data, including Google location data, to also determine the approximate location at which a device with Google location history activated was used at particular time or ranges of time. So what certain devices were used and when. The government expects that expert 2 will also testify about the process of determining the device location, the collection and use of location history data by Google, how it works, location history data produced in response to a search warrant, right? They got all of X's stuff. And they also want the graphical representation prepared by expert 1. So they're also going to comment on this. Well, how'd they get all that? And how does that work? His or her testimony will aid the jury in understanding the movement of individuals towards the Capitol area during and after Trump's speech. And then, right, those two are kind of general witnesses. But then we get to the one that really matters. Expert number 3. Now, expert number 3, this person has knowledge, skill, experience, and training and education beyond the ordinary layperson regarding the analysis of cellular phone data, including the use of Twitter and other applications on cell phones. So they gobble the whole thing. The government expects that expert 3 will testify that he or she, number 1, extracted and processed the data from the White House cell phones used by Trump. So the device that was used by the defendant, Trump, and one individual who we don't know who that is. Individual 1. So they're going to go pull it all out. They extracted and processed the data from the White House cell phone that they assigned to Trump. Now, I don't know what personal cell phone, White House assigned cell phone, whatever. But he turned it back in. Turn in your keys and your badge and your gun, Trump, insurrectionist. Here's your cell phone. And he leaves. And so they pull it all off. So they also say that how they got it, okay, how they jacked everything off of it, but then also reviewed and analyzed the data on Trump's phone, what they did with it, including analyzing images found on the phones and websites visited. So is Trump going to, like Wikipedia, and typing how to seize power in a country? What is the definition of insurrection? All right, something like that. Is that what they're planning on? And 3, determine the usage of these phones throughout the post-election period, including on or around January 6th. Specifically identified periods of time during which the phone was unlocked. Oh, and the Twitter application was open on January 6th. So they pulled the logs. So they pulled the logs out so they can just see Trump is just scrolling on Twitter, right? He's like, oh, he's just scrolling. Okay, Capitol buildings being insurrected. And this guy's just like, scrolling around, right? They can see. How long was he on there? What else was he looking at? Was he tweeting at the time? Well, he was. He definitely tweeted a video message. And so they're trying to analyze this, right? And see what's happening there. Now, also images. Was he taking pictures? What websites did he go to? Insurrection.com? Who knows? Determine the usage of the phones during the post-election period. And this is serious stuff. I mean, they're going to be using this selectively, picking out whatever. And they're going to say, oh, that text message is used for insurrection. And that is insurrection. And you search for that, which is insurrection. And blah, blah, blah. Okay. So your cell phones are obviously, not sacred spaces when they're in the possession of law enforcement, but neither is the president's. And they just gobbled the whole thing up. They got all of his X account, all of his Twitter account has been, gobbled up. If you liked anything that he posted as well, they gobbled it up. Yeah. And then when he said, go home in peace, they actually closed the Twitter account. So he was on it and then they X'd it out. Very strange. So the person who wrote this one was Thomas Wyndham, Jack Smith, special counsel, going after Trump's cell phone now, in addition to everything else, including Melania's sock drawer. But that was the original filing. Now, you might be asking yourself, how is this even feasible? How can they, get away with garbage like this? Well, it's because it's orchestrated in part of a political operation. And Eric Holder, who is Obama's former attorney general, might still be running things at the AG. Who really knows, since Obama's probably running most of the White House as well. He explains exactly how this works. So if you're wondering, wait a minute, how did they just go and get access to his cell phone and his sock drawer with Melania there and so on and so forth? How can this happen when we have things in this country like due process of law, equal protection under the law? You're supposed to have judges that sign off on warrants. You're supposed to have agents that swear an oath to uphold the law and blah, 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 all this nonsense, right? We all just remember from a bygone era. But this is Holder explaining exactly how it works. Now, he's going to talk about it in the context of Trump, but just pay close attention to it. This is exactly, literally what they're doing. This is the playbook.
Sure. If the president told a compliant attorney general, I don't like what this congressman said about me or did about
Biden
me,
to Garland.
did to me over the course of the last 2-3 years, whatever, open an investigation on that person.
Just like
that attorney general could tell a compliant United States attorney to do just that.
Yeah.
Talk to a compliant FBI director who could be placed by the president president to open an investigation and then to just look through that person's life and look for anything that you possibly can find. And who's to say what you find in any person's life that might run afoul of the law? And even beyond that, the mere fact of an investigation of a person who is a public figure can be reputation ruining, can be politically damaging, not even if you find anything, just the fact that the investigation itself exists. And if you've got the full weight of the Justice Department, the full weight of the presidency, the full weight of the FBI focusing on somebody like that, that can be extremely damaging to not only that person individually, but to our democracy writ large.
Yeah, you're right about that, Eric Holder. You nailed it, man. Absolutely home run. Well done. So why are the Democrats doing that? Why is your party doing that? Maybe he could answer that question. CNN is, of course, not going to ask. They're going to base this on Hunter Biden. Poor Hunter is being prosecuted, right? Meanwhile, that's their entire strategy. So that's how they do it. Now, when they are prosecuting you in this new regime, you also don't get access to discovery. So if you think that you've been charged with a crime, well, at least you can be advised about what the evidence shows against you, right? I mean, this is still America. Wrong. Jack Smith objects. Trump wants access to material. Sorry. Government is in opposition, objecting to Donald Trump's discovery motions. How dare he get access to material he needs? They write this in a 45-pager out of Judge Chutkan's courtroom. They say, Judge Chutkan, Donald Trump demands an unprecedented expansion of the government's discovery obligations that would provide Trump with special treatment and result in a delay of this case. They say Trump asks this court to find that a wide array of entities, both inside and outside the executive branch, are part of our team, right? Jack Smith just wants to say, no, it's like me and Molly and Jay. There's like nobody else working on this case. It's just us three. We just have sleepover parties and tickle fights with Judge Areola. But it's just us. It's a small team. This is not true, obviously, right? The CIA was involved in the cover-up with Michael Morrell saying, I just don't like Trump, and orchestrating with Anthony Blinken to psyop all of America. Okay, so we want to know who else was involved in this election rigging that goes to Trump's main thrust of this claim, which is he is allowed to speak about a rigged election as the executive of the country. So he wants to expand this. What does the FBI know? What does the CIA know? What does the NSA know? What does the DOD know? What does everybody else who is involved in this know? But they just want to limit it down. They want a small hula hoop versus a big hula hoop. So they continue. Jack Smith's team says, and Trump, he further demands that the government search the files of all of those separate entities, like the FBI and CIA, for broad categories of information that are not even relevant to our case. Says Trump's view of discovery is untethered to any statute or rule and lacks anything that justifies it here. And the information he seeks is not even in the government's possession, right? Listen to this term, okay? The government's very sneaky here. The government, in my position, is anybody who's collecting a check from the federal government or even in the chain of that, right? If you're doing work and collecting from a contractor that's being paid by the government, all right? You are an agent of the government. So the government is monstrous. It's not like Jack Smith, Jay Bratt, and Molly, right? It's bigger than that. But no, it's not in our possession. We don't know where it is. There's a lot of buildings in the government, but it's not in our office, so we don't have it. And she says, in many cases, what they ask for, it does not even appear to exist, because maybe it was deleted with Liz Cheney's records. In any event, it's not even discoverable under the rules, under Brady. It's not discoverable under the criminal rules of procedure, and therefore Trump's motion should be denied. Now they say, Your Honor, Judge Chutkan, to camouflage that his demands are unsupported by the facts or the law, Trump confusingly separates his discovery claim into two separate motions. One, to determine in the abstract the scope of the prosecution team, how big is the hula hoop, without any reference to documents, and then making a separate filing as well. And the government sets forth below why he fails on both fronts. They say, first of all, the scope of the prosecution's team has already been established, okay? We have rules like Brady that tell us exactly how all of this works. And they say the closely aligned prosecution is here. It's limited to entities that have significantly cooperated with and provided substantial information to the government's investigation. So you don't get everything that you want. It's got to be closely connected. Now here, only where the relationship exists and the government has access to the documents, will the courts consider whether the government should obtain the documents, right? And the courts basically have recognized that the government is a big, disgusting monstrosity, my words, not theirs, and that it's really hard for the government to go navigate through the twisted web of bureaucracy to obtain documents, right? So it's like a lot of work for them to do that, and they don't have an obligation to go comb through every other agency just because somebody requested it. They say, as we've explained, Your Honor, the test demonstrates that Trump can't even meet the standards, and so you have to find in our favor. They say, first, Trump, his argument just creates an entirely new test of law that doesn't even matter. And then he cites to this claim, which says that executive branch branch agencies are very broad. And third, he also relies on factors that have nothing to do with whether the entity in question is even closely aligned with the prosecution. So his tests are all wrong. And besides, the things he's asking for, he's not even shown that he needs them yet. He's not showing that they're material to this case. And the rules say, Rule 16, that it needs to be material. Saying overbroad discovery requests, Trump asking for things that he doesn't need, is against the rules. It's cumulative information, and he's not entitled to it. Now, as Trump has done elsewhere, Trump miscasts the relevant case law, and he incorrectly asserts that materiality only requires some abstract logical relationship to the case. But here, Trump is actually stating the opposite of what the law requires, and he misquoted the Fifth Circuit, and they're dum-dums over there. And he says also that Trump is talking about potentially classified information, but he doesn't even know what's in there. And by the way, he's not even entitled. The classified material is not even discoverable in the first place. And so that is the reason, Your Honor, Chutkan, that you should reject his arguments. Said he seeks to add to the prosecution team an entirely separate investigation. Now, this is something we've been seeing out of these cases for a while that's pretty disgusting. When the Proud Boys were on trial or the Oath Keepers were on trial, they would say, well, there's a bunch of undercover FBI informants or other informants. We don't know who they are, but where did they come from? And the government would just say, well, they didn't come from the FBI, so there's nothing that we need to do about it. We learned that they're from HSI, Homeland Security Investigations, right? And there's, apparently dozens, if not hundreds. I don't know the final number. It'd be nice if they told us, honestly. But a lot of people, 50 at least, that were identified by the Proud Boys defense attorneys in court, and they just segment them out. They say, no, you're outside of the hula hoop, right? You're outside of the scope. We don't need those people to actually incriminate you, and they're not part of our case. So they say, Trump is saying, well, I don't care if they're not a part of our case. They might have information that is Brady that exonerates me, and I need to know what they were up to so I can prepare my defense. Well, they say, sorry, Trump wants the government to add a separate investigation, distinct components of the DOJ, which is called the Department of Homeland Security. They're like, that's an entirely different building, man. And there's 250,000 employees over there. Oh my gosh, 250,000 people at DHS. Can you imagine? Now, they also want to add the nation's entire military apparatus, which is 3 million strong, and the 18 federal agencies that comprise the intelligence community, and a now defunct committee of a separate branch of government, which is the illegally constituted January 6th committee, right? Which was that one. So Trump says, yeah, I want it all, man. Milley was involved. Milley was with the DOD. We know the CIA was involved with the laptop cover-up letter. We're talking about election rigging, right? So yeah, it does extend to all of these other things. And Trump wants to know. They say Trump has already received the discovery that we've got in possession of the government. And so their definition of the government is like their little closet of, prosecutors and agencies that they say are closely aligned with the prosecution, right? But they got a bunch of records, as we know, from the January 6th committee as well. So saying the court should reject Trump's boundless arguments based on factual misstatements as well. Now, they say that Trump says that the prosecution team should encompass a lot of people, the entire special counsel's office, including staff and everybody in the Southern District of Florida. But the government has taken a broad approach to discovery. They're saying, we've given you a ton of information. Yeah, 13 million pages. The government also included in this case items overlapping with Florida. And this practice will continue. We're continuing to dump all sorts of material in there. In some, Trump demands relief for a problem that does not exist. So she's saying, look, we've given you a ton of material. We've given you 13, 14, 15 million pages of documents. Trump says, well, we don't care about those 15 million pages. We want that. We want those 5,000. That's it. She says, you don't need those 5,000 though, because you got 13 million, right? And that's the argument she's making. Now they say Trump, next, he tries to define the prosecution team to also include everybody in the DC, Washington office. And remember what happened, right? Like these people were Molly was already working adverse and opposed to Trump well before Jack Smith was appointed. Same with Thomas Wyndham. So when Jack Smith got appointed, he just gobbled up these people. They just all got promoted to the special counsel team. So Trump is saying, great, I want to know what they were doing when they were in DC during their investigation. And they're saying this is just misplaced. The special counsel, they say, is completely separate from these other entities. And they don't answer to the U.S. attorney for DC. And they don't answer to us. And so we have done our due diligence. And Trump knows that, saying his principal complaint appears to be from the Capitol breach cases, which is what the DC office is attending to. But they say the government has made Trump offers and he's not responding to their requests. And so his complaint is undercut. He's not even searching the database like he wants to. Who wrote this? Is this Molly who wrote this? Oh gosh. No, it's Thomas. Okay, Thomas wrote it. All right. Sounds a little bit whiny like Molly. All right, I'm not sure. They're both very whiny. It's hard to tell. So rather than pursue and review the discovery available to him, Trump attempts to use as a cudgel the government's unaccepted offers of access to review these things. And so Trump is not even using what we're offering him, so therefore he should not get more. Now, they're saying that he also wants access to the Washington field office. He also wants access to the DOJ headquarters. They're saying he did get some stuff from the DOJ, but he's making broad assertions about this, and it's not specific enough for us to give him information from the DOJ. Trump also wants stuff from Homeland Security, obviously. They say, he moves over here, focusing the scope of the prosecution arguments on the Secret Service and CISA, two agencies that we would like to know more about. But here again, they say Trump fails. He doesn't need discovery from them. Why does he need evidence to know what they know? Secret Service is only there on there were text messages that day that apparently have gone missing. So where'd those go? And CISA was apparently the ones responsible for a robust cybersecurity of a rigged election. So shouldn't they have information that Trump should get as part of the discovery? But our own government, the people who say, no, due process of law, no one's above the law. They want to prosecute someone without any evidence, without giving them, they have all of the evidence, to be crystal clear about this. Like, it's the government, the DOJ has it, or can get it, but Trump can't review it. And they don't have any obligation, their argument is, to go get it. Now here they say Trump fails because he's already been provided with the material related to those agencies that is in our possession. Okay, so we've given him everything we got, which is how they work. They just don't go get things, so they don't have to give anything and then say, well, we don't have any obligation to get it. Now they say first about the Secret Service, much, if not all, of the discoverable material from it was obtained through compulsory process, demonstrating the agency is not part of the prosecution team. Okay, so Jack Smith had to go order it and demand it from the Secret Service. Now, in addition, that material, which they say is only marginally relevant, which no one cares about their opinion on that. Like, the defense wants it. They're making the argument to the judge, but the defense says it's very relevant. So thanks for your opinion. And yet it constitutes a sizable portion of the discovery. They say it's already been given it to them, but not all of it. Much, if not all, right? So you see how sneaky these people are? It's already been given to him. Not all of it. Though the defendant points to the fact that the government obtained during the investigation. So they're saying, okay, here's the things that we want. And the defense always wants the things that they're not going to give to them, obviously. Trump points to the fact that the government obtained during the investigation several official phones from Secret Service employees. Now, he says he fails to inform the court that the phones did not contain any recoverable information. Isn't that nice? Phones were deleted. And that though he informed that the government intended to return the phones to the Secret Service, Trump failed to interpose an objection. So the data's deleted. Weird. Now, finally, additional Secret Service information contained in the discovery database that Trump's not looking up. And so against this backdrop, Trump fails to identify a single item or category of items from Secret Service or DHS more broadly that he does not already have, that he says he needs, or that will significantly alter the quantum of proof in his favor. This is definitely a Thomas motion based on that one. Quantum of proof. All right. Thanks, Thomas. Now, the defendant's arguments over material from CISA are also unavailing, saying Trump suggests that CISA assisted in the investigations and he should be able to review the discovery. But even under that, they say the facts don't show that he's entitled to this. As part of our investigation, the government interviewed a single CISA employee, and that's all. And we've already given them everything. And now they say he wants access to the DNI, the CIA, and the DOD as well. But he's not offering facts. Instead, it's just baseless conjecture. Now, he asserts, Trump, that the DOD assisted in the investigation, but without more specificity, they say we can't find anything. So Trump says, I need some things. And they say, well, unless you're specific about it, I can't give it to you. And you say, well, I don't know what you have. Well, we can't tell you what we have, but I want to see it so I can prepare my defense. Well, I'm happy to give it to you, but you have to tell me what you need. I know, but you have everything, and I just need to see what you have so I can make my requests. Well, happy to oblige, but where would you like me to start? Now, absent such specificity, for what Trump requests is for the government to search the holdings of a military apparatus that employs 3 million people. You want us to search through everybody's email inboxes, huh? Now, it's an investigation. The government has interviewed one then current and now former DOD official, which is a small number of the former DOD officials, and we've already given the defense to everything else that they need. And they've also, everything related to the DOD that we got from the select committee, we've also given over. Now, they say they also want information from the CIA, which would be nice. Now, they want this as well. The defendant tries to import that the CIA was part of the prosecution team because the CIA was working with the special counsel. But unlike this, CIA is a separate investigation, okay? So they're doing separate business. It's CIA business. You're not entitled to know, or we'll have to kill you. So they say here, right, also, finally, from the Congressional Select Committee, they say, finally, Trump speculates about coordination and extensive access to argue that the prosecution team includes Liz Cheney and everybody else. But there's no authority for this. And it's overbroad. And it's a separate branch of government. And in any event, we've already produced things that we've gotten from the select committee, and there's no reason why we should be ordered to go get more. And say, therefore, courts here, Judge Chutkan, you should deny Donald Trump's discovery demands because he fails in its entirety. And you can see a lot more law in motion here as we get through the bottom of this. A lot of this is barred. In conclusion, he's asking you to make us do a bunch of stuff that we're not entitled or required to do. He's failed to establish the materiality for any of them. And so why should he get any evidence against him? I mean, it's just America. We gave him what he needs, right? It's like 100,000 million pages of just, New York Times trash articles that nobody cares about. They're like, no, it's discovery. You'll like it. So it's Thomas Wyndham signing it, signed off on by Molly. I'm sure she proofread this thing. It sounds like a team effort. But that was submitted opposing Trump's attempts to get discovery. Now, Jack Smith is also taking this to the Supreme Court and trying to get them to accelerate this case because it's basically on hold now until we can get this immunity issue resolved. But the Supreme Court accepted the case, kind of. We'll see what they do next, but this was an order that came out Monday, December 11th. Jack Smith saying, do we have the right to even prosecute this guy? And can you decide on this quickly, please? Court came out, says Jack Smith's motion to expedite consideration of the petition for a writ of certiorari before judgment is granted, and respondent Trump is directed to file a response on the petition before 4 p.m. on Wednesday, December 20th. And so you see that is what has been filed. Now, Donald Trump has responded to this, and the government is getting a little bit nervous because if this goes against them, Jack Smith's case could be over. Here is what Liz Harrington with the Trump team posted. She said this, that crooked Joe Biden's henchmen and more. Trump explains. December 11th, 2023, a statement from a Trump spokesman on deranged Jack Smith's filing with SCOTUS saying, crooked Joe Biden's henchmen, deranged Jack Smith, that portion of the gag order was overruled, is so obsessed with interfering with the 2024 presidential election with the goal of preventing President Trump from retaking the Oval Office, as the president is poised to do, that Smith is willing to try for a Hail Mary by racing to the Supreme Court and attempting to bypass the appellate process. Deranged may need to be reminded that the Supreme Court has not been kind to him, including by handing down a rare unanimous rebuke when the court overturned him 8-0 in the McDonald case. As President Trump has said over and over again, this prosecution is completely politically motivated. There is absolutely no reason to rush this sham to trial except to injure President Trump and tens of millions of supporters. President Trump will continue to fight for justice and oppose these authoritarian tactics. Trump spokesman. Now that's the statement on December 11th, and I agree with that, and I think that's the right play. No reason to rush this. Take your sweet time. Just work its way up, and we'll see what the Supreme Court does. But if the Supreme Court does find in Trump's favor and just resolve this thing, relatively quickly, no, the president's immune, obviously, without much fanfare, not going to be good for him, and they're getting a little nervous about this. So some people in the media are trying to cope their way through this bad deal. We were here yesterday saying Jack Smith is panicked, man. They just freaked out, and that's why they filed 3 simultaneous motions. One with Chutkan saying, no, you can keep the trial on the track. One with the Court of Appeals saying, please accelerate this and find in our favor, and one with SCOTUS, because they have to have this March date go. Because if they can't have it go in March, what are they going to reschedule it for 6 months in September? No, not with the election around the corner. So it might have to go into 2025, and they would absolutely hate that. And so a lot of cope out there on CNN and MSNBC. Jack Smith's very smart by having to go to the Supreme Court. He's boxing Trump in. No, my friends. They're getting boxed out here. They're running out of time, and they're hitting the panic button. And so this guy actually, to his credit, makes the same point. He's acknowledging, look, all that happens here, if the Supreme Court comes back down and finds Trump has immunity, cases are gone. So it's kind of a twofer thing, right? We were happy to get to the Supreme Court. We were just expecting it to take a little longer. Like Jack Smith fast-tracked it for us. Thanks, Jack. Here is what the outcome might be.
Paula said that she doesn't think that a ruling on this case would necessarily impact any of the other criminal cases Trump is facing. Do you agree?
So I agree with Paula 99% of the time. I slightly disagree on this one. If Donald Trump is to win here, obviously Jack Smith's federal election interference case is out the window. I also think Fani Willis's case is doomed. Yes, that is a state-level case, but the principles of immunity would apply whether it's a federal or state-level prosecution. Again, that's if Trump wins. I do agree with Paula. This will have no impact on the hush money case because that conduct almost entirely happened before Trump was president, and it definitely will not impact the federal Mar-a-Lago classified documents case because that conduct was entirely after Donald Trump was president. But if he wins here, I think 2 of the 4 cases are going to be out the window.
Alyssa, Mr. Trump was supposed to testify testify in his New York trial
today.
So
they switch over to New York. Nobody cares. So that is interesting, right? And that's exactly right. If immunity comes down, I think both those cases are over. And also, the Florida case, they're going to say obstruction happened after the fact, and it's really a separate issue. Yeah, so it's going to be a lot of fun. So they're a little nervous about that. And so is this lawyer. Democrat super lawyer Marc Elias, some people might say the architect of the legal onslaught that Republicans faced in 2020, is starting to hit the panic button himself. This is what he sounded like on this guy's show. And he posted, he said on his X, he said, "Hear my message loud and clear. If you vote for Jill, RFK, no labels, you're voting for Trump."
Anything other than
mad.
And let me just tell you something. If you think voting for Jill Stein is doing anything other than electing Donald Trump, you are wrong. If you vote for Jill Stein, you're voting for Donald Trump. If you vote for Bobby Kennedy, you are voting for Donald Trump. If you vote for the no labels candidate, whoever he or she is, I don't even care. I don't even want to know. Don't spare me. It's going to be a Democrat or a Republican or Joe Manchin or this person. If you vote for the no labels candidate, you are voting for Donald Trump. And I'll tell you one more thing. If you sit at home because you're disappointed, or you sit at home because you think your vote doesn't matter, or you sit at home for whatever reason and you don't vote, you're helping elect Donald Trump. So, I'm tired of the people who are saying we need, I'm going to have a protest, or I'm going to sit out, or, we're disappointed because the Supreme Court, struck down the student loan. Joe Biden fought for student loan relief. Joe Biden has fought for more things than he's given credit for. But even if those were aside, if you don't participate in this election and enthusiastically drag your friends, your neighbors, your family, drag them to the polls, make sure they're registered, drag them to the polls and make sure they vote, then you are feeding into what Donald Trump wants for this country, which is a dictatorship.
Oh, a dictatorship. So you know what to do, my friends. I guess vote for a dictator, I guess, is where this is going. So we're going to be dragging up people to the polls, and I think we're going to drag more people to the polls this time around there, Mark. And we have to overcome the margin of fraud that was instituted last time. And so you can see a little bit nervous out there. You add that to Jen Psaki. Jen Psaki's telling people, hey, there's like 533 journalists who are imprisoned. You say, does Trump have anything to do with that at all? No, but he talked to Putin once. Okay, thanks, Jen. Thanks, Mark. They're nervous. There's a reason for it. Their attempts are not working, and the date is just dripping through their fingers, and they were not expecting that, man. Jack Smith just hit it 3 times, and he leapfrogged the Court of Appeals, going right to SCOTUS because the clock is ticking. And my friends, we'll be here to continue to cover it. Thank you for subscribing. We're covering all the Trump trials and more. We'll look forward to seeing you here. Thanks for checking out robertgovea.com, and thanks for checking out the shop and grabbing a new hat at robertgovea.com, the new Watcher hat, and learn more about the Watcher symbol over there. And we'll look forward to seeing you right back here on the next one.